Top of the hour. Welcome back to Court TV Live. I'm Ted Rollins. Before we went to commercial break, we saw the defendant in the courtroom waiting to hear her fate. Let's go back to Orlando, Florida, and find out what happens to Danielle Redlick.
Okay, ladies and gentlemen, my understanding is that you have reached a verdict. Is that correct? Yes. Okay, would you please hand the verdict forms to the deputy, please?
In the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 2019 CF 18460, State of Florida versus Danielle Justine Redlick. Verdict as to count 1, we the jury find the defendant not guilty. So say we all. Signed, juror badge number 283, foreperson. Special finding, this page was left blank. Verdict as to count 2, we, the jury, find the defendant guilty of tampering with physical evidence as charged in the information. So say we all. Signed, juror badge number 283, foreperson, dated at Orlando, Orange County, Florida, on the 17th day of June, 2022.
And would you please poll the jury?
Yes, ma'am. Juror badge number 283, are these your true and correct verdicts? Juror badge number 18, are these your true and correct verdicts? Juror badge number 220, are these your true and correct verdicts? Juror badge number 238, are these your true and correct verdicts? Juror badge number 356, are these your true and correct verdicts? And juror badge number 5345, are these your true and correct verdicts?
Yes, ma'am.
Thank you.
Ladies and gentlemen, I wish to thank you for your time and your consideration of this case. No juror can ever be required to talk about its discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases, and we have recognized for hundreds of years that a jury's deliberations, its discussions, and its votes should remain their private affair as long as they wish it. So, the law gives you a unique privilege not to speak about the jury's work. And although you are at liberty to speak with anyone about your deliberations, you are also at liberty not to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And so on behalf of the Chief Judge of this circuit, Chief Judge Lisa Munyon, I want to thank all of you for the 2 weeks that you have spent with us in serving your civic duty and serving as a juror on this case. Your duties are now discharged and you are excused. Have a wonderful day. Take care. You're welcome, sir.
Sure is.
Thank you. Ms. Redlick, a judgment of acquittal will be entered for you on count number 1. A judgment adjudicating you guilty is entered on count number 2. State, is there any legal reason we cannot proceed to sentencing today?
Yes, Your Honor. She's entitled to a PSI, but also want a chance for any sort of impact testimony to be offered. So that's why.
Okay. I will ask Mr. Parnell, who's standing. She is entitled to the PSI. Do you wish to waive the PSI and go forward with sentencing, or do you want to have a PSI ordered and I will set sentencing off?
If we end up setting sentencing off, then I would be asking for her release, because at this point, she's going to score 16 points. The jury has not made a finding that would allow for the court to sentence her to prison. Her credit at this point is 3.5 years. And I don't want her sitting in jail longer, which would essentially be adding and extending a prison sentence. So if we want to go ahead today, I understand victim impact, they have a right to do that. So if we set it off, then I'd be asking for the court to release her and set the sentencing date in the future.
Mr. Wiggins, state's position?
Or the state would like to explore the possibility of the imposition of an upward departure, and so I don't believe that would be necessary at this time.
Okay, so I will set sentencing off. Let me set sentencing for August 5th at 10 o'clock. And I'll have that set. I think an hour should be sufficient for that. Betsy, can I have a calendar for August? Can we have a calendar for? Any sentencing memoranda that the parties intend to file for the court's consideration need to be filed by July 15th, close of business on that day. Was there a bond on count number 2, or I believe proof evident presumption great was found on count number 1. What was the bond on count number 2?
I don't know, Your Honor.
I don't.
Okay.
Okay, so the bond on count number 5, she has a bond. It's raised to $15,000. That's always been in place.
Judge, may I approach with case law?
Sure.
This is not, this is for position that in order to sentence her above essentially a county jail sentence, if she does not score 22 points on the score sheet, which I believe we should be around 16.2 here, then the jury would have to make a finding as to her dangerousness. That has not been found by the jury. And so I think a sentence above time served or potentially probation would be unlawful, and that therefore every day she spends in jail awaiting that, whether she has a bond or not, would also be unlawful.
It doesn't appear from my cursory review that the Brown case speaks directly on your point regarding the fact that this defendant here has a bond in place right now, that there isn't a finding that the court is holding her. She has been granted a bond pursuant to Florida statute. Help me understand more about how Brown
As to the bond,
is applicable in this case.
As to the bond issue, I don't think it touches on that. I think what we're getting at is that whenever she is sentenced,
Okay.
it cannot be to higher than the days she has already served, that she has credit for time served.
Okay.
And keeping her in jail until that date is essentially holding her to what we know she cannot be sentenced to. It's time that she can't get.
Okay. I don't find that Brown is applicable in this particular situation. I'm not sentencing her today. I'm setting sentencing off for August 5th. She has a bond in place. She can make bond and she will be released. I'm not changing the conditions of her bond. So your motion for me to release her today will be denied. Anything further from the state that I need to take up?
No, Your Honor.
Defense.
Don't think so.
Okay.
We'll write a motion if we need to.
All right, sounds good. All right, so we are adjourned. Everyone have a good day and be safe.
Wow. Not guilty of second-degree murder. They didn't find her guilty on the lesser, the manslaughter. Danielle Redlick isn't going home tonight. Her attorney tried to make that happen, but she will be free sooner than later. Possibly, worst case scenario, August 5th, but likely she could be out before that. What a shocker for some people. A lot of people thought that the evidence was there, that there was enough for the state of Florida to get that top conviction, and then, well, maybe they'd find her guilty of the manslaughter charge, and she'd do 8 years. There she goes out of the courtroom and walks out victoriously. Let's bring in Joe Tamburino and Marie Pereira, who have been watching along with us. And Joe, I heard you probably 15 minutes ago saying, no, I think she's going top charge. Your thoughts?
I'm completely shocked. I mean, you never know what juries are going to do. And obviously, the prosecutor should have been objecting more. You know, we were just talking about this with Julie, letting in the diary and letting in a whole bunch of different things. So, but I'm shocked. I am.
At the end of the day, she was humanized, Marie. Whether you liked her or didn't, she wasn't. She was. Her life was brought out through her testimony and through the other things that Joe talked about. Your reaction to this verdict?
I'm not shocked at all. I kind of called it, and I said that she would get manslaughter because they didn't prove evil intent required by second-degree murder. It was an unintentional killing of this man, the way he was stabbed by the shoulder, under the armpit, while he was towering over her. I think the defense did a great job at proving he had no evil intent when the actual accidental killing of her husband occurred. And the verdict reflects that.
Joe, take us into the mind of the participants here. You've been through this many times when you're sitting at that table. First, before the verdict is read, that feeling, what is it like? And then when the verdict goes your way after so much preparation and time, what's it like?
Well, it's high stakes poker. I mean, you're on the edge of your seat, especially in this kind of a case where she was offered what I thought was a very good deal at the beginning, 8 years, and she decided to roll the dice and won. But yes, it's very much high stakes poker. And when you're waiting for that jury to come in, nerves are very raw, very high. And the only thing you can do is just try to keep calm and wait till they read the verdict.
Marie, on the other hand, I don't want to be presumptuous, but I'm sure you've lost a case, at least one in your day. What's it like after all that preparation and then the opposite comes through and you truly believe? Because one thing, you could say what you want about Sean Wiggins, there's no doubt that this man thought that Danielle Redlick should be held accountable for her husband's death. Your thoughts on what's it like to lose?
It's very difficult to lose, especially when you find yourself trying to vindicate the death of a person who was made out to be a villain, and you really believe that this person was a victim. It feels like you're in an elevator, and then all of a sudden it drops from like the 20th floor to the bottom without any notice. It's really a high anxiety situation.
Joe, let's get your opinion on the sentencing part of the equation here. The state immediately didn't want sentencing to happen right now. They want to fight for an upward departure. The defense pointing out that basically she's looking at time served if you go by the statutes and the sentencing guidelines. What's your thought on that, making her stay behind bars until August 5th?
I'm with the defense on that because the defense attorney made a very good argument about this. if the state wanted to get an aggravated sentence, they have to put that forth in front of the jury and have a jury make a finding on it. Most states agree with that. It goes back to Blakely v. Washington, U.S. Supreme Court case. So I really didn't understand why the judge did not release her, because it seemed like the prosecutor did not put in front of the jury the issues of an aggravating or aggravating factors. So I was a little confused at that, but I think the defense made a good argument, and I would have agreed with them.
Yeah, we watched that play out in your neck of the woods with Chauvin, where the Blakely was a big part of it, and that upward departure was announced out of the gate. Marie, your thoughts in terms of the state, pushing for that and making her stay another month and a month and a half in behind bars?
I agree with Joe, and according to the law, really, she should have been released. However, this is a highly emotional case, and I think the judge is a person just like anyone else. And the fact is, she really didn't get charged with the top charge. And what I think the judge is saying is, listen, be happy, out soon, let's not push the envelope here, basically.
Yeah, you could see her defense attorney, too, whispering to her during that whole process, don't worry about it, you're going home. Eventually, you're going home. Let's watch this dramatic verdict. If in case you missed it, she was facing the possibility, Danielle Redlick was, of spending the rest of her life behind bars, and the opposite happened. Take a look.
Verdict as to count 1. We, the jury, find the defendant not guilty. So say we all. Signed, juror badge number 283, foreperson. Special finding, this page was left blank. Verdict as to count 2. We, the jury, find the defendant guilty of tampering with physical evidence as charged in the information. So say we all. Signed, juror badge number 283, foreperson, dated at Orlando, Orange County, Florida, on the 17th day of June, 2022.
There was her reaction. You can only imagine what she was going through during those moments, waiting to hear her fate. Afterwards, she did say thank you as the jurors walked out. Joe Tamburino, they had a choice, second degree. Manslaughter was also on that verdict form, and then the other option was not guilty. Did they have manslaughter in the bag, in your estimation, in terms of the evidence?
I thought they did, because, I mean, manslaughter doesn't require any type of specific intent. Manslaughter is just that you did something that was unintentional that obviously caused harm, in this case, death. So I thought they had that.
Marie, your thoughts as well. I mean, I know that's what you predicted, and it seems as though, waiting 11 hours while somebody has been stabbed and they're in the same dwelling, that intent is not required. Or were you surprised they didn't check that box?
I'm surprised that they didn't check the box, but again, I think her testimony proved that she was a victim of domestic violence, and that had a lot to do with their verdict. And I also think the location of the wound, the way the man died quickly, and they had experts really verifying that his bleeding out was almost instant. I think that the defense attorney proved that, and it reflects in the verdict.
Yeah, and we felt the emotion of this verdict being read on television. We were watching it. What about being in the courtroom? Well, Court TV legal correspondent Julia Janae was in the courtroom. She is now outside the courthouse. Take us through it, Julia. What a shocker.
Ted, a shocker. You could feel it in the gallery when everyone was looking at each other to see if we actually heard not guilty from this jury after 4 hours. Now, this jury, their faces, their body language when they walked in, looking back now, it was an indicator of what was going to come down, because I noticed, first off, they looked chipper. They looked pleasant. I tweeted about it. They're coming in, but they look like they're rather happy, which usually you don't see jurors looking. You'd see them looking more somber when they have to hand down a heavy sentence of murder for someone, even if there's someone who it's clear that they did it. But these jurors, they were sharing smirks between each other. They looked like it was the top of the morning, not lunch, and they hadn't had it yet. But they walked in, sat down. It's only 6 of them. I could see them much more clearly today because I got a chance to sit on the other side of the courtroom to actually see all of their faces, including the women. When they walked out, they really just looked like we are people who have completed our service, and we feel very good about the decision. decision that we've come to. And they all looked like they were getting along, like there really weren't any fights going on over this case inside of that jury room. Of course, after we heard that not guilty, Danielle Redlick's reaction seemed to be inquisitive, and then it set in that she is going to be possibly going home, not in prison for up to the rest of her life. We talked to the defense attorney, Andrew Parnell, on his way out. He did say it's the policy of their public defender's office that they cannot comment, but he did say if she can post bond that she will be going home today, and that would be bond on just the tampering with evidence charge. She had no bond for that second-degree murder charge, but now that she has been acquitted of murder, it's very likely that she could be a free woman by the end of the day.
Wow, fascinating. And boy, the stakes just so high. We saw her, from our vantage point, the camera picked up Danielle saying thank you to the jury. Did you pick up on that, and did you see any reaction from jurors? Did she make eye contact or just randomly say it?
I could see her looking at them. I didn't see them looking back at her in that moment, but they were looking over to her. You could tell that they felt good about their decision and knew that this was someone that they wanted to. They believed and they wanted to send home. So I can't stress enough how happy, how upbeat this jury looked when they heard their verdict read into the record. They walked out. They didn't look back at her as they were escorted out of the courtroom, and you just saw her melt into the defense table. It's what we saw sometimes during this trial where she looked tired and exhausted, but this was a look of relief, of disbelief even, that this was finally over. There is the sentencing that she still has to contend with for the tampering with evidence. That only carries a sentence of up to 5 years, and you heard her attorney say that he'll be arguing for time served. She's already been in 3 years, and the maximum for tampering with evidence here in Florida is 5 years. So a major, major win for this defense team. Andrew Parnell and Catherine Conlon there representing Danielle Redlick.
The idea that she's going home possibly tonight. What is she going home to? Do we know? And we saw that her relationship, obviously, with her children is going to be complicated. Her sister did come in and they exchanged smiles. Who's been there for her? Has anyone been there for her in the courtroom? What can you tell us?
It's a great question, Ted, because that's the thing that's been missing in this trial that is different from other trials. I was asking around as the verdict was being read and everyone was filing out for any new faces that I saw to see if they were potentially family, but everyone was just connected to the state attorney's office or the public defender's office or the courthouse in some way, and that's been the trend in the gallery, that there have not been people who were personally connected to either the defendant or the victim there for long periods of time. I did learn from a court staff member that there may have been some family here yesterday. No, Jaden Redlick did testify, the 18-year-old, and there have been personal people who came in with her, seemingly just there to support her as she testified against her mother twice in this case. And there were some people who seemed to stay. We weren't sure who they were. They didn't make themselves known. It was not clear who they were there with, but we understand that they may have been members of the family, but not sure which side they were there supporting, and they were not here for this verdict being read. So it was very quiet inside of the gallery, where you would expect to perhaps hear those sobs, hear relief, hear happiness or sadness. You really didn't hear that from this gallery because everyone was disinterested of sorts. It was people who were connected to the courthouse or to the media.
We had our camera obviously on the defendant during the reading of the verdict. Did you pick up any other reaction from Sean Wiggins or from anybody else in the courtroom of note when that not guilty verdict came in?
You know, stillness from this prosecution team. They were fierce in the way that they prosecuted this case, just a command inside of the courtroom, and then to hear not guilty, it seemed to catch them even off guard, especially since they were pushing for second-degree murder and even saying that this wasn't manslaughter. And the compromise would have been, if you didn't feel that they proved this case beyond a reasonable doubt on second-degree murder, then that manslaughter would have been what this jury came back with. But they had three options on that verdict form. They could either choose second-degree murder, manslaughter, or not guilty. They chose not guilty. That's why you didn't hear any reading or back and forth on manslaughter, because they simply had those three options, and they chose that bottom one, not guilty of that top charge.
Yeah, what a dramatic day in Orlando, Florida, in that courtroom. Julia Janae there watching it along with all of us, but she was in there, and she said she felt it. Julia Janae, thank you. You'll be reporting throughout the day on Court TV here as we unravel this decision. Let's bring back Joe Tamburino and Marie Pereira for more reaction. As we move forward here, Joe, in your experience, these are difficult decisions. We're talking about the family members. So what does she go home to? You know, and especially when you've got your daughter testifying against you, who knows what the relationship is with her son. This is a mother who clearly, you know, one thing that came out at trial was this was a mother that was attentive to her children, went to the sporting events and was there. But how do you, on the back end of something like this with your clients, what do you give in terms of advice, and how difficult is it for some people, as great a news as this is? She's been in prison. She's been in jail for 3 years plus now. There's an acclimation period, is there not?
Absolutely. And the thing about it, in murder cases, you will have clients who are staying in custody. I've had them for 1 or possibly 2 years. Now, we had the pandemic, which probably, you know, caused some delays in this case as well to do 3 years. But you do talk to your client about, if we win this, hopefully you're going to be able to go home. What kind of support do you have? Now, in a case like this, where it's, you know, interfamilial type of homicide, you're going to need support that's outside of your immediate family, because we can see what happened with this family throughout this whole case. But you do talk to your client about what kind of support will you have when you get back out there.
Marie, in your experience, how difficult is this? Can this be? I mean, obviously, this is a great day for her. Let's not sugarcoat it. That she's very pleased, but there's a acclimation, if you will, with society and family and everything else.
You know what? She was found not guilty by a jury of her peers, but it doesn't end there for her. It's very important that she has her freedom, but there has to be now a mending of her children. Clearly, she was a good mother before this happens, and motherhood is a lifetime thing, and now she's estranged from her kids. I anticipate that social services is probably going to still be involved in their lives. I mean, she has a little son. Her daughter's 18 now, but I don't think they're just going to hand over her son to her. I think they're going to do some screening. I think she needs therapy. She needs help. And I think this decision was a win for DV victims. And it says, you know what, you don't have to wait until you're stabbed to defend yourself. I think it says, you know what, we believe you, and we believe domestic violence takes place in different shapes and forms: intimidation, control, isolation. It doesn't always have to be, you know what, I'm shooting you, and you don't have to wait until that happens before you defend yourself.
As we watch again the reaction from Danielle Redlick, she's in she's not sure what's happening. Her attorney had to show her and tell her what was going on. Joe, what are the odds of an upward departure at the on the back end? Like you said, it should have been through the Blakely declaration or some point. Do you think the state has much of a chance here of getting an upward departure, or do you think that indeed this will be a time-served scenario?
I think this would be a time-served scenario, because the law is quite clear. When you want to give any defendant more time than what your state guidelines or law calls for any given offense, you have to prove other factors. And those have to be proven beyond a reasonable doubt to the trier of fact. In this case, the trier of fact is a jury. You could waive a jury and have a judge do it, but in this case, it was with a jury. So unless the prosecutor brought out those facts at trial and was specifically going to ask for an aggravated sentence, I don't think he has a leg to stand on.
Yeah, it'll be fascinating to see it all play out. And we'll find out what happens to her on August 5th. That's the sentencing date, August 5th, 10 a.m. It has been set by the judge. The state has indicated that they want to push forward an upward departure, which basically means above the state guidelines, that they want her to spend more time in prison or jail. She's done 3 years, likely not going to happen. We want to thank Joe Tamburino and Marie Pereira for sticking around with us today, watching all of this come through. It was a shocking a reaction, to say the least, for a lot of people. But the jury spoke, they watched, they saw all of the evidence, and that is that, not guilty on the top charge.